Thank you for attending this meeting of the Revere Election Commission. We are here to hear the petition for recount put before us by Mayor Dan Rizzo. We are all members of the board that are appointed by the mayor, and we'll hear from Lauren Goldberg.
I'm going to use the microphone so that the TV can hear me. Thank you for having me here today. As you indicate, my name is Lauren Goldberg from the law firm of Kopelman and Page. Just so that you know a little bit about my background, in my previous work before I joined Kopelman and Page, I was the legal counsel to the state's elections division. I've been dealing with recounts and other election matters since that time, so that's been over 18 years. So today you have before you a recount petition that has the correct number of certified signatures, and so is before you for action today. And essentially, we are going to be discussing first a series of facts that are relevant to your discussions or your decision today, and then the law that is applicable to the facts as we agree is relevant. So just to summarize, on November 3rd, 2015, a citywide election was conducted to elect a candidate to the office of mayor. Two candidates appeared on the ballot, current Mayor Daniel Rizzo and Councilor Brian Arrigo. After the polls closed, the Election Commission certified the election results, with Mayor Rizzo receiving 5,091 votes and Councilor Arrigo receiving 5,209 votes. There were 11 write-ins and 101 blanks. On November 13th, at approximately 11:38, the Office of the Election Commissioners received a recount petition submitted by Mr. Paul Rizzo on behalf of the mayor. Mr. Paul Rizzo also submitted a typewritten document that was purportedly written by the mayor. The document states in relevant part that I have reviewed the petitions for recount and I hereby authorize and appoint Paul Rizzo to execute on my behalf the candidate certification on all petitions for recount in all wards as if personally signed and executed by me. The document was not signed with a typewritten signature, but was signed electronically with the designation /S/Daniel Rizzo, so signed by. The recount petition for each ward appears to have been signed by Paul Rizzo and includes his name rather than the mayor's. Thereafter, later that day on approximately 3:53, the Board of Election Commissioners received a handwritten letter indicating that Mayor Rizzo was requesting a recount. The letter appears to be signed by Mayor Rizzo and was delivered to the Office of the Election Commissioners by fax. The election commissioner recognized, Ms. Colella, recognized the signature on the letter and believed it to be that of the mayor. Election Commissioner Colella then contacted the Elections Division and spoke with the director, who indicated that such requests were likely not sufficient to constitute a valid request for a recount unless the election commissioners received by 5:00 p.m. a signed original of that request for a recount. The request for a recount has not been rescinded, and as of this date, no original signature has been received in connection with the request for a recount. Ms. Colella, can you confirm, are those facts accurate as I've described them? Okay. I would like for the commission to take a vote to put those facts before the entire commission. So if someone could say so moved, and then a vote. Okay. So you could say aye if you, okay. All right. This is not a public hearing today, and so this isn't the kind of thing where rules of evidence apply. This is an opportunity for the Board of Election Commissioners to discuss how to handle the recount petitions. And as we're talking about what the law requires, under Chapter 54, Section 135, which is the recount statute, it says that a written request for a recount has to be received in addition to the signatures. It doesn't appear to require that they be on the same petition form, and in fact, there is a case that recognizes that it could be accompanied by a petition. I mean, the request could be accompanied by a petition. The real issue is that under 54-135, it's that the petition be accompanied by a written request and that written request be signed by the candidate, okay? So what I've done is essentially to summarize the arguments and the law in support of accepting the petition, i.e. finding that the petition meets the requirements of the law and moving forward with scheduling a recount, and those that support rejecting the petition, in that essentially a finding that the petition does not meet the requirements of the law and therefore cannot initiate the process. I'm just going to start with the arguments in support of accepting the petition. Essentially, Massachusetts courts, and let me also say, I'm sorry, let me back up for 1 second. So there's two issues that we're looking at as well. One is whether the facts was good enough or sufficient under state law to constitute a request for a recount. And then two, if it wasn't, whether the power of attorney / signature by Mr. Paul Rizzo on the petitions was good enough to stand in the stead of that original request signed by the mayor. So under state law, Massachusetts courts require substantial compliance with procedural requirements for conducting recounts and for elections generally. And typically, the court will not invalidate a recount or an election or a petition even unless there's a substantial deviation from the statutory requirement. But most of those cases, and there's two in particular, are looking backward at a challenge to a recount petition that comes up after the recount has already been held. Here we're looking at whether these petitions in the first instance meet the requirements of the law. So we're in a little bit of a different standing from that. So in the case of DeJordi v. Board of Registrars of Uxbridge, the court found that a candidate's failure to use the form supplied by the Secretary of State was not something that should invalidate the entire recount, where the petitioner's request incorporated all of the essential elements of the form. And so that's essentially what a writing the type of that was faxed would suffice for that purpose. That's the argument. So then we move on to the statutory language itself doesn't specifically require an original signature. It says a writing signed by the candidate. So a request signed by the candidate. So it doesn't specifically require an original signature. In addition, I'm not aware of any Massachusetts law that addresses the question of a fax in this context. And in fact, there is some case law, again, outside of the election context that says, I'm reading now from the case of Commonwealth v. Johnson. It says, we see no persuasive reason to preclude a trial judge from relying on a facsimile signature of a notary public as sufficient verification that the signer swore to the contents of the certificate. It is a well-established principle that in the absence of a statutory directive, a signature may be affixed in many different ways, written by hand or stamped, printed, or affixed by other means. So there's some support in case law that a fax could suffice for a written signature. We found one case from a different jurisdiction from New Jersey, Madden v. Hagedorn, and that case did find that a candidate was able to be placed on the ballot for a primary where a petition received by fax prior to the deadline was then followed up after the deadline by an original signature. So there's that one case. So the infirmity in the fax delivery was cured by a delivery of an original signature. In this matter, it appears that the mayor's signature is genuine and that he wishes for the recount to proceed. Other than the fact that this fax document is not an original, it complies otherwise with the statute and doesn't appear on its face that it would vitiate the accuracy of the request, meaning it appears to be a request from the mayor. Turning now to the power of attorney, and that is a separate writing that purports to give Mr. Paul Rizzo the authority to act in the place of the mayor. Similarly, outside of the election context, there is support for that idea. There's nothing in state law that requires that a power of attorney be in writing or be notarized. It can be verbal, unless the underlying statute or action requires that there be a notarization. So for example, if a person were to sign a deed, they would have to have their signature notarized, and so a power of attorney purporting to give someone else to sign, the authority to sign their name would also have to include a notarization because the underlying action requires that. Generally, one acting under a grant of power of attorney stands in the shoes of the principal, and the principal is responsible for the acts of the agent. Massachusetts courts have relied on this in other contexts, that the act of signing may be accomplished by print, stamp, or hand of another in the context of this power of attorney. And again, the statute doesn't specify the manner in which the signature of the candidate was to be provided. Here, we know, and we are fairly assuming that the document, the various petitions were signed on behalf of the mayor by Mr. Paul Rizzo, with his consent and at his direction. And where there hasn't been any request to rescind the request for a recount, it doesn't appear that any defect as a result of the power of attorney would result in some violation of the election law. We don't have any reason to believe, in other words, that the request isn't something that was made at the mayor's direction and with his consent. Okay, so that's an outline of the arguments in support of accepting the petition. I do want to point out that there's a significant amount of case law in both inside and outside of the election context that I've relied on in preparing my comments today. And we can go through each of the cases, but basically, once you've heard the arguments on both sides, it's really an opportunity for you to talk about how the facts of this situation should be considered. So I've read you the arguments in support. Now I'm going to explain the arguments against, and then I'm available to answer any questions that you might have. And also, the board should feel free to deliberate, obviously. So in election law, and again, these are the arguments against, there's essentially a significant amount of case law that says that actions in error by members of a Board of Election Commissioner or city or town clerk shouldn't be held against the voters, okay? That is not the situation that we have here. This isn't about whether the commission did or didn't do anything proper. Instead, the real question is whether the voter, in this case, the mayor, in his request, substantially comply with the election law. And the way that the law kind of analyzes that is it says technical requirements shouldn't make the rights of voters insecure, but voters are required to comply, as we're saying, substantially with the law. And so really part of the decision-making process for this board is to decide whether the facts and the power of attorney substantially complied with the law. In terms of whether this board has authority to be thinking about these matters, and in my view they do, under Dane v. Registrars of Voters, which is a case about the board of registrars considering voter registration affidavits, the court said you can look beyond just what's exactly in front of you if there's something that's so significant that it makes you ask the question. So just because someone, I'm just going to use there's a case in Worcester where there's lots of students were registering from a college address. And so the court said, just because someone's registering from Worcester doesn't mean that that's enough to look behind. You're going to rely on the affidavit signed by the voter. But if they're all registering from that college address, then that might be a reason to look. And same thing in this Dane v. Registrars of Voters case. All of these voters were registering from a prison address. And so the court said that's enough. And you can look behind once you have seen that that all the voters are coming from that address. So similarly here, because the candidate signature block right on the petition says Paul Rizzo instead of Dan Rizzo, I think that's significant enough to allow you to ask these questions. And also since the fax was received with the request. So in this case then, what were the requirements of the election laws? A person seeking a recount, a candidate seeking a recount, has 10 days following the date of the election to submit their paperwork. So here, the paperwork was presented midday on the last day to submit, which again, as long as it was in by the deadline, if it meets the other requirements, that's fine. But there was that time period. As we've said, it wasn't signed by the candidate, as we know, or even have the candidate's name if it was signed by the power of attorney. And there was the facsimile. As a result of this, the election commissioner called over to the Secretary of State's office to say, can you provide me with any guidance in this area? And the Secretary of State's office indicated to the election commissioner that the request would need to be an original signature received no later than 5:00 p.m. I also spoke with them, and they gave that same comment, or provided that same comment to me. Out of personal experience, I know that they require this not only for candidates for nomination papers for state office, but also for questions to be put on the ballot on a state ballot. So Proposition 2.5 questions, Community Preservation Act questions. And I did confirm with the director of the Elections Division that if the Elections Division were to receive a petition for a district-wide recount without an original signature, they would reject it. And that decision would be, in my view, given some deference by a reviewing court. Deadlines for election laws as it applies to voters are very significant. So, for example, submission of nomination papers after a deadline would be rejected after the deadline. Failure to get a notarization on your withdrawal for a candidate would be rejected if the notarization was absent or if it was submitted after the deadline. And there's case law that says, for example, that if a voter doesn't follow the rules when they're filling out their ballot, then their vote can't be counted. So for example, if you vote for 2 when it's vote for 1, even if you voted for the same person, it would look like an overvote and it would be counted as a blank by the machine anyway. That there was failing to complete the voter affidavit on the outside of an absentee ballot application, absentee ballot envelope would result in the ballot not being counted. So there's a requirement that there be some level of compliance. See, as the case law and the power of attorney law with respect to both the faxes and power of attorney were not in the election law context. And state election law comprehensively regulates the signing of nomination papers, petitions for ballot questions, and recount petitions. Essentially, the process, when there is an intent to allow someone else to sign on your behalf, it actually says so in the statute. So a written acceptance under Chapter 50, Section 1 means acceptance signed personally or by an attorney duly authorized in writing. 53, Section 5 says no such certificate shall be valid unless the written acceptance of the candidate. 53.7 says a person signing a nomination paper signs in person, but any voter who's prevented by physical disability from writing may authorize another person to write his or her name and residence in his or her presence. And there's 5 other instances where a personal signing is required in the general laws. There's also sections outside of the election law where it's clarified that someone's name, just their name alone will suffice to be a signature, or when a fax is specifically authorized. And then finally, this concept that for election laws, the Board of Election Commissioners or boards of registrars in towns aren't supposed to have to go behind the materials that are sent to them to verify that they are appropriate. Instead, it's supposed to be a comparison. For example, for certifying signatures in the McCarthy case, you look at the voting list, and then you look at the signatures that appear in the petition. And you just compare the two, and if the person's name is on the voting list, even if it was put there by fraud or forgery, that the idea is that the election commissioner shouldn't have to go behind. It should be a ministerial function. And so not submitting an original and submitting a fax or a power of attorney would require some amount of review, as has happened in this case. So based on those concepts, this idea of not by technical requirements making the right to vote insecure, as compared to this concept of in voting actions, it's really supposed to be the action of the individual unless the law suggests otherwise or provides an avenue specifically otherwise. And trying to decide then, if you were to decide that these petitions are in apparent conformity with law, then what you would do today is vote to authorize the scheduling of a recount. If you decide that the facts and the circumstances as described mean that the petitions are not in substantial compliance with the law, then you would vote to reject the petitions. If there was a very clear-cut answer, I think I would be standing here before you to make a recommendation on how to handle this situation. In the most legal terms I can come up with, this is a gray area in my view. There's no right answer and no wrong answer. It's the answer that this board feels comfortable with. And what happens after this, whether the candidates are satisfied with the decision of the board or not satisfied with the decision of the board, really isn't something to make a decision, to rest your decision on. You just have to look at the particular facts before you and consider what you believe should be done with these petitions. Thank you, Madam Chair. So this would be a time to talk or to ask questions if you have them.
Could I ask one question
Certainly.
regarding the materials we received? Is there any ordering of them as far as the petition versus the letter from the mayor with his intent?
Certainly. The question, I'll just repeat it because it wasn't directly into the microphone, was there any issue with the order in which these were received? So the petitions themselves were received earlier in the day, and the faxed request was received later in the day. In my view, as long as the proper materials were filed by 5:00 p.m., the order in which they were received is not something that the election laws would distinguish.
Then are we ready to take a motion for how we'd like to vote? Okay.
Madam Chair, I did take the liberty of preparing alternate motions for you. The first one is a motion to accept the petitions, finding them in substantial compliance with the law, and the second is a motion to reject the petitions, finding that they are not. I do want to make sure that if there are any further questions or about the process normally used in the Office of the Election Commissioner, about what the Secretary of State's office had to say, that this is really the time to have that portion of the conversation. And I know it may be that you don't, that you have an inclination based on what the office would normally do, and that's, that's what you're comfortable with, and that's fine. But this is the opportunity to have that conversation if there are any questions about that.
All the materials are there. Right? The reason why materials are correct. Right?
Oh, no.
Let me just see if I can assist for 1 second. I wanted to also tell you before you take any vote what the results of this vote might be. If you were to vote to accept the petitions, then after this, and that would be by a vote of more than one. So as long as you have a vote 2 or more to take the positive action, then that would be what would ensue. If for any reason you were to tie in your vote, that would be no action because there wouldn't be a majority in favor or against. Just so that you know, a vote of 1 to nothing, just in case anyone were to abstain, is also not a vote, meaning nothing would result from that. And so essentially that would be, it would be the end of the process at this level for now. Okay. Is there some question about, so what would typically happen in a situation like this now is that someone would make a motion, and it could be these in one of these forms, and then someone would second. If someone seconds, then there could be further deliberation if necessary, and if there is no further deliberation, you could take the vote. I would recommend you do a roll call. There's not that many of you, but we certainly can keep track of that. And then you would take your vote, and then the meeting could be adjourned thereafter.
Oh. He had.
Yeah, yes.
Oh, he had while you were out of the room. Oh, sure. I'm sorry. Well, does anyone have a?
This was wireless, you can pass that.
Oh, okay. Does anyone have any additional questions on the board?
I don't. Yep.
Does anyone want to make a motion?
No, I think through.
Okay.
I think we should take about 10 minutes to.
Let me just
talking about.
I just want to remind you that because this is an open meeting, you have to talk out loud in a voice that others can hear. And I know that that's, it can feel awkward, especially when you're in the process of deliberating, but because we're in an open meeting, you do have to do that. So it's fine. I mean, anything that you might say that's procedural or that's substantive, it's fine to just ask it, and certainly will help to address your question.
Okay, sorry.
Any comments?
Any other comments? No?
No, I just wanted to read this.
Okay. Oh, I'm sorry. Yes.
Madam Chairwoman, it's because this is not a public hearing, the only people that have the ability to talk are the board members and myself, since you've allowed me to do so. I would want to remind you that even a little back and forth should just happen in the microphone, and that way there's no risk. Or speak out nice and loud. Even if the TV can't catch it, it's still enough for the members, the people in the room to hear it. So, as I said, I know it can be somewhat awkward, but no questions are stupid questions, and I'm happy to assist with anything that may come up.
Thank you.
Any questions?
Then I'll move to make the motion. And I move, based on the facts at this meeting, that we reject the recount petition filed on behalf of Mayor Daniel Rizzo on the grounds that it is not apparent conformity with law, and as it does not substantially comply with the requirements of Massachusetts General Law, Chapter 54, Section 135, insofar as, although the petition forms were received by the Board of Election Commissioners before 5 o'clock post-meridian on the 10th day following the election, the petitions were not accompanied by an original written request for recount signed by the candidate on whose behalf the recount is being conducted. And further, the petitions themselves were not signed by the candidate or even contain the candidate's name in the candidate's certification block. All those in favor? Oh, do I have a second on the board? No. So where does this leave us?
So there's been a motion, but no second. Does someone else want to make a motion? Okay, so in that case, it would appear that the result or the effect of not taking a vote is for no action on the petitions, and so there would be no further action taken because there's been no decision about whether they are or are not in conformity with law. There is I mean, we're still at an open meeting, so there's still time to choose to take some official action. You know, the benefit of taking action one way or the other is that it then allows the process to move forward to the next phase, and whether that phase is to schedule a recount or to not schedule a recount, in either situation it could be appealed by either of the interested parties. And just so that we can talk briefly about that, if that were to happen, the commission could take what I typically call a, quote, passive defense, whereby the real parties in interest, the two candidates, would be able to make the legal arguments, essentially some of what I argued today, but be able to kind of take that further, submit it with the legal citations and any case law that they felt was relevant, and then a judge could decide whether the recount should go forward or not. So that is the benefit of moving forward in one way or another.
we have a minute or two to talk, or?
Certainly, this is an opportunity to talk, and perhaps when there's a failed motion, it's a good idea to talk about what the issues are and what people think or don't think about the petitions.
May I just ask, a failed motion means, a failed motion means no action is taken.
A failed motion will mean no action is taken because essentially the Board of Registrars hasn't chosen, the Board of Election Commissioners hasn't chosen to accept the petitions and schedule a recount. And that's what this meeting is about, whether to accept the petitions, or in other words, to determine what legal impact the petitions have as currently filed.
So my motion was in the negative.
I would like to just say that upon receipt of the petitions, I called the Secretary of State's office, and I was advised that although an election commissioner has to accept whatever is presented to her, we had to timestamp it and certify the signatures. It was the opinion of the legal counsel at the Secretary of State's office that the recount petitions were not in conformity with Massachusetts general laws. And I just want that to go on record. And I was advised that exactly that. And that was from legal counsel. Only because I had never encountered such a situation and I wasn't sure on what to do or how to act or how to proceed with them. I had no other course of action but to call the Secretary of State's office. That's it. It's a very uncomfortable I apologize. I just want to, you know, it's a very uncomfortable position to be in. We've spent many hours trying to come to a workable solution, but when you just read the law and look at the documentation, that's all said. I'm fine. Thank you.
Madam Chair, if no one else has anything to add, I don't know if you maybe want to renew your motion and see if it's seconded, and then you could at least take a vote up or down on your motion.
Okay.
So you could just say, I'd like to renew my motion.
I'd like to renew my motion. Do I hear a second? No second?
All right,
So we're in an impasse?
and no one wants to make a motion to accept the petition. Is that the case? All right. So, Madam Chair, I don't know if there's anything else to add here, and unless anyone else has something to contribute, it seems to me at this point that it would be appropriate for you to take a motion to close the meeting and dissolve the meeting of the Board of Registrars. The Board of Election.
Does anyone else have anything to add from the board?
I just feel that everything is correct, that what was done. And that's just what I have to say about it.
What do you mean? What was correct?
Well, in other words, all the paperwork and everything was okay, was done properly.
With the law?
Yeah. That's what I have to say about it.
So would you like to make a motion to approve the recount petition?
I'll make a motion to approve the recount petition.
Is there a second?
Sure.
George, it's an open meeting, you don't participate, thank you, just that. You know that, you know that, you know that.
We have no second.
Okay.
So I believe at this point, I'll close this open meeting of the Election Commission for the City of Revere on the recount petition for the office of mayor. Thank you.